Hi, this is Attorney Mike Grevlin coming to you from Chicago as usual, and today we got a quick little one. It's just a sovereign citizen. I guess she's showing us her preparation for a remote hearing that she's having. It does not go well. I guess we're gonna call this a sovereign citizen court fail. Let's do it.
Good morning, friends.
Good morning.
And this is a video that I am producing specifically for today's August 16th, 2021. They call it a hearing on the Connecticut Judicial Branch.
Yeah, that's what they call it. Okay, so you got a hearing today. Woo! Took a while to spit that one out.
A remote hearing.
Yep, because you're not there.
I have responded to these charges since October of last year. Correctly. I
highly doubt that, but it doesn't matter. Your hearing's set for today, and it's remote. Let's carry on.
I've made my special appearance in court several times on these charges.
I'm sure you have.
They're still not going away because the state does not want them to go away.
Yeah, they probably don't. They probably want you convicted on something. That would be the whole point. That's the state's idea in a case.
Let me see if I can.
I can't imagine what the problem would be with this awesome presentation.
Well, that's what I'll do. I'm going to read what I sent to the court on public record, because really the only court that I have that's even semi-competent would be the court of public opinion, and that's in 18 years of litigation of what I've been going through as a bona fide, notorious Connecticut whistleblower. Connecticut and many others hate my guts.
Well, I don't know the background, but so far you're pretty annoying.
I had filed
Don't forget to hit like. The boys would really appreciate it, unless you have something against Frankie and Ollie.
affidavit of status.
Are you kidding me?
Affidavit of facts.
Wait, we're going vertical on a computer monitor and missing most of the text.
Notarized and certified mail. I sent this a few months ago directly to the Division of Criminal Justice Commissioner, Supreme Court Justice Patrick McDonald, and they never got back to me on this affidavit of status, affidavit of facts. So I expanded it.
Wow. They never got back to you. That is incredibly believable, considering what you've said so far.
The library on Saturday, and I entered a few things pointing out that I have already supplied in these cases a lawful notification letter and notice of liability, a Brady motion, a notice of special appearance, a writ of habeas corpus, a bill of complaint in equity, presentment to void proceedings, jurisdiction, an acceptance of oath, conditional acceptance upon proof, notice of liability.
Okay, so you hit him with a bunch of irrelevant nonsense, and I'm sure that none of it may, furthered anybody's understanding of anything. So,
motion for disqualification of judicial authority and motion to remove the law office of Pat Brown. Affidavit of status, affidavit of facts. This is what you see here today, as well as having sent it a few months ago. I made a mistake on this. It's supposed to be August 14th. I'm just going to read the rest of it, I guess. In lieu of video conference appearance demanded by the court under threat, I request the scanned documents sent as attachments in an email sent from Grantsville, Utah Library on August 14th, 2021, coupled with my YouTube appearance and testimony sent via email to the court under several individual names of the parties involved. In lieu of video conference appearance, I request court orders to all of the documents I submitted from October 2020 to present as seen above. In order to proceed, I request the court to establish jurisdiction in writing per the orders issued. I request that all filed attorney grievances and Judicial Review Council complaints, CHRO, EEOC, HUD Fair Housing, and active verified complaint for a declaratory ruling before CHRO are ruled upon before proceeding with the prosecution in the 11 criminal motor vehicle charges on the docket in state of Connecticut versus.
Wow, that's all you need to know. I was wondering what the underlying stuff is, but it's auto stuff, and she's citing everything under the sun. She does have an affidavit of facts, which is proof positive that she knows nothing about anything. Still going on jurisdiction. She, by her claims, she's been at it 18 years, and she still hasn't accepted jurisdiction. I can't even.
Mary Bagnaschi. Well, it's actually state of Connecticut versus, of course, we know the all-cap Bagnaschi Mary E name. Got to make their money. I request all the charges be put on the trial list until such time jurisdiction is established, with the state providing evidence as requested and legally lawfully required to establish contract that the living woman, I, Mary, do not consent to having the corporate.
I just feel bad for this dog. The dog is just whining for attention over there, and you know I'm a dog lover, and she's just prattling on. The attorneys and the judge in this case, they're getting paid to do it, but that poor dog is just being neglected.
Fiction all-cap name used as surety by the state without my prior knowledge or consent. My status as a living woman, creation of God, with unalienable rights to life, liberty, and the pursuit of happiness is protected in the First Amendment of the Constitution and the Freedom of Religious Clause. I have no respect for persons as one of God's people, and without an oath or written consent to be the U.S. citizen, 14th Amendment person, the state has no jurisdiction to bind me to your corporate statutes, rules, ordinances, and codes. I am a sovereign American state national, living woman of God, not a dead corporate vessel. The corporate unknowingly assigned all-cap name, cuspid, and social security number for Sesta Q Trust to provide equity I did not even know existed by way.
Yeah, because it doesn't exist, and really, what you are is a bad dog owner right now. That's all I'm hearing through all of your nonsense. That's all I'm getting.
Of the deception and fraud. If it is established, indeed, the court does have jurisdiction, and it is already known to have jurisdiction.
The court has jurisdiction.
Say hi to Blue.
Oh,
He's ready to go for his walk this morning.
Poor baby.
Folks, this is the fourth time that this motion in this format since 2020 has been. It's on the floor. It's on the record right now. It's in the file 4 times.
Well, the phrase you're looking for is the 4th time it's been brought. It hasn't been granted because it's a loser. In substance, everything you're saying is wrong. This is not shocking. What is shocking is that a court is allowing it to go on, although I don't know the underlying merits of the situation. I'm sure the judge is not reading it because it's meritless at this point.
This motion has been before the court all the way to the Supreme Court since 2012 and to the appellate court 2 or 3 times by me and Attorney Deborah Stevenson.
And you haven't won yet, have you? Charges are still pending.
This is the motion. I demand this court and or state attorneys make application pursuant to authority of section 54-47B for an investigatory grand jury into crimes committed by the Torrington government and certain state executive, legislative, and judicial branch officers involving corruption and the unlawful use of physical force and multiple false arrests and imprisonments and 10.
Yeah, no, that's not what's going on here. You're being charged with crimes, okay, and you are now injecting wild allegations into this that nobody believes, that are not going anywhere, and are distracting from the merits of the case.
Years of malicious prosecution, gross misconduct used to intimidate and coerce the petitioner herein. These scanned documents, oh, here's the acceptance of oath, conditional acceptance upon proof, notice of liability. Already sent once to the court. This one's actually entered on court record, and I'm sending it again. The other two things.
Oh yeah, they're gonna want another copy of that. Oh Lord. Oh, how do they do it?
That I'm sending are references. My landlord here since March wrote a beautiful reference, and so did my friend Lynn.
Wait a second. We've been litigating this for 18 years, and you think now's the time to drop references from your landlord? I can't imagine how it's relevant, but even if it was, at this stage of the game, okay.
Wow.
Well, there you have it. It wasn't too exciting visually, but Sovereign Citizen, she ticked every box. She completed every bingo card on the planet with her ramblings. That is out there. She just went on. I can tell you, as an officer of the court, none of that made any sense. Just as you suspected. But if you're curious, did she hit upon something that made sense? No, she didn't. Just pure soft sit nonsense. I don't even want to know, but if this thing actually went on for 18 years, that is just awful. And multiple trips to the appellate court. She keeps saying that she keeps doing the same things and they're not working. Well, yeah, they shouldn't work. I'm surprised that she just hasn't been convicted of whatever the underlying offense is by now already and sentenced, but that's where we are. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.